Hello, my name is Paul Meinrich. I am a family law attorney. I'm in Santa Ana, Orange County, California. I've been in practice for approximately 37 years, just over 37 years. During that time, I have done many different things, but since the late 1980s, I've specialized in concentrated in doing family law cases. I am state certified, that's by the State Bar of California. So what I would like to do in this video is basically to introduce myself. If you need an attorney, it's important that you get along with that person, and so this is to give you a little feedback as to how I am and whether you might feel comfortable with me in representing you. I would also like to do that by providing a little bit of information, in this case with regard to premarital agreements. Premarital agreements is a topic that comes up in family law practice, and I'd like to provide some information about that. So first of all, what is a premarital agreement? A premarital agreement is an agreement between two prospective married partners that is going to alter the way in which our state law deals with the property of the marriage. There's community property and there's separate property. Community property being property acquired during marriage, and separate property acquired by generally the spouses before marriage, or perhaps by a gift or an inheritance during marriage. And how that property is going to be divided and characterized as one kind of property or the other is something that a premarital agreement can do. Our state law allows for that, and to change what is called community and what is called separate property. Also, our state law provides that you can change what otherwise may be the law's approach to the issue of spousal support. You can even waive spousal support in the event of a divorce case, and waive it in a premarital agreement. So it's primarily important for those two reasons. The issue comes up oftentimes because either someone's been through a divorce before, or they're concerned about what is going to happen with the property that they may have prior to marriage in a divorce case, and they want to make sure that perhaps they end up with at least what they had prior to marriage if a divorce happens. And those are all realistic expectations, and those are all issues that can be addressed in a premarital agreement. But it's not always quite as easy as it sounds, because when someone comes to me and says, well, I'd like to make sure that I end up with at least what I have prior to the time of marriage, that may involve a number of different issues that are not easily understood right at the get-go. For example, let's say that person has a home. Well, that home may be separate property and in that person's name only. Let's say it's the prospective husband's property. Well, once the marriage occurs, if that home is going to be paid for in part by community earnings, namely wages and salary of either one of the parties after the time of marriage, that community may be acquiring an interest in that person's separate property home that they may not even expect to occur. So that's an issue that can be addressed in a premarital agreement. The husband with that separate property home may want to refinance. And as a requirement, the lender may require that the wife sign on to the loan because her income may be needed to qualify for the loan, and they may ask that the wife's name be put on title. Well, when that happens, you may just have made a gift to the community, so to speak, or transmuted that property to the community from separate property to the community. And then the law applies differently in that situation than it would if the property were just kept in one of the parties' names. So these are all issues that can be addressed. Regarding the spousal support issue, you can waive spousal support. However, there is a clause in our state law that says if the enforcement of that waiver would be unconscionable at the time of the divorce, the court may disregard it. So there's an escape clause there that our law provides, which is only fair because circumstances may drastically change. But you can use your own creativity in coming up with division of property and spousal support clauses in a premarital agreement. It's oftentimes difficult to talk about that agreement, but I would suggest that if you're going to decide to get married, broach that subject early on, because if it's important to you, it should be important to the other side. Talk about it early and talk about what your expectations are and put it on the table, because The good way of approaching it may be to say, honey, we already have a premarital agreement in the form of the state law that will apply to our case. If we want to make changes, that's just better for us so that it's more predictable and we each know what we're likely to get out of the marriage if it should end. So it's good planning. That's one approach that you may want to take. So that's just a little bit. There's a lot more to it on premarital agreements. If you feel that I could help or you want to talk about it further, there's some information on the website that I have. If you want to talk with me personally, that'd be great. I do not charge for an initial consultation. I can talk about what I can and can't do, and we can decide how best you can be helped. Thank you very much.